Hello everyone, welcome back. This is the lecture that is going to aim at the PYQs of for CBI exam. So here's a paper in front of you. This is the exam of 2015. It has 120 questions and we are going to discuss each of the questions over here. So let us begin. First question is the committee recommending the appointment of CVC consists of committee में कौन से लोग आते हैं? The PM and the Union Home Minister. The PM, the Union Home Minister and the leader of the opposition in the House of People. CGI and 5 other senior judges of the Supreme Court. The Prime Minister, leaders of opposition in both the Houses of Parliament and the Union Law Minister. So, the correct answer over here is B. The correct answer over here is B. The CVC can hold office for a term of 4 years, 4 years or till he attains the age of 67 years, whichever is earlier, or 65 years, or 5 years or till he attains the age of 67 years, whichever is earlier. Correct answer is option number C. 4 years or till he attains the age of 65 years, whichever is earlier. On ceasing to hold office, the CVC shall be eligible for further employment to any office under the GOI, eligible for any diplomatic assignment only, eligible for appointment as an administrator of a UT, or ineligible for further appointment to any office of profit under the government. The correct answer is option number D. The Central Vigilance Commission is duty bound to present to the President a report as to the work done annually, every 3 months, every 6 months, or at least 3 times in a year. So this is annually. Question number 5. The President shall cause the report of the CVC to be laid before Lok Sabha, Rajya Sabha, each House of Parliament, a joint seating of both the Houses of Parliament. Each House of Parliament. Under the provisions of the IT Act, a digital signature certificate issued by a certifying authority can be never be revoked if the subscriber makes a request, be revoked depending upon the kind of certification issued, or be revoked if there is a disagreement between the partners of a firm. It can be revoked if the subscriber makes a request. IT Act provides all offences under the Act are compoundable. Offences other than those punishable by imprisonment for life or for a term exceeding 3 years are compoundable with certain exceptions. Offences other than those committed against a company or corporation are compoundable. None of the offences under this Act are compoundable. Correct answer is option number B. For the purpose of Section 13 of the IT Act, if the originator or the addressee has more than one place of business, which one of the following shall be the place of the business? It would be the principal place of business. Principal place of business. Under the provisions of IT Act, cyber cafe means a place having internet connection, establishment having internet access, any facility from where access to the internet is offered by any person in the ordinary course of business to the members of the public, or an establishment having 24 hours internet access. It is option number C. Under the provisions of IT Act, electronic signature does not include signature, includes digital signature, may include digital signature, includes digital signature unless expressly excluded. It includes digital signature. According to the Prevention of Corruption Act 1988, which one of the following is not correct? A sub-inspector of Delhi Special Police Establishment is authorized to investigate a matter generally without the order of or JMIC. Option B. In Ahmedabad, Assistant Commissioner of Police is authorized to investigate a matter generally without order of the or JMIC. In Kanpur, a DSP is authorized to investigate a matter generally without order of or JMIC. In Mumbai, a Assistant Commissioner of Police is authorized to investigate a matter generally without the order of MM or JMIC. So, incorrect statement is the first one. When an element is made by the bribe giver in a proceeding against a public servant under the provisions of PCA, stating that he offered gratification to the public servant, is liable for the abatement of the offence, shall not be liable on that ground as an abettor, will be entitled for a reward under the provisions of the Act, or can be tried jointly with the public servant. It shall be B. PCA provides for punishment of offences committed by public servants only, those who influence public servant by corrupt or illegal means, public servant as well as those who influence the public servant and abet the commission of offences by public servants, members of parliament and legislature. Correct answer is C. Who out of the following cannot be a special judge under the PCA? So, a CGM. A CGM. The maximum number of special judges to be appointed under the provisions of PCA for any area can be 5, 3, 2, or as many as necessary. It is as many as necessary. The superintendence of the DSPE, insofar as it relates to investigation of offences alleged to have been committed under the PCA, shall vest in the central government, Delhi government, CVC, or the Lieutenant Governor of Delhi. It is CVC. The Delhi Special Police Establishment Act extends to whole of India. It extends to whole of India. Nothing contained in Section 5 of the Delhi Special Police Establishment Act 1946 shall be deemed to enable any member of the establishment to exercise powers and jurisdiction in any area in a state without the consent of central government, Director DSPE, CVC, or the government of the state. It is the government of the state. The Director, Delhi Special Police Establishment shall hold office for a period of not less than 2 years. The Delhi Special Police Establishment is empowered to investigate all offences, offences directed by the Government of Delhi, offences notified by the central government, or all offences which the establishment deems fit. Option number C. A, in good faith, believing property belongs to Z, to be A's own property, takes that property out of B's possession. A has committed the offence of theft, no offence, criminal misappropriation of property, or cheating. Option C. A is committing robbery. B is attempting to commit robbery. C is present and aiding A in a robbery, while D and E are present and aiding B in attempting to commit robbery. If all of them are conjointly doing this, then A is guilty of robbery, B attempt to commit robbery, and C, D, and E are guilty of abetment of robbery. Or all are guilty of criminal conspiracy, or all are guilty of committing robbery with common intention, or all are guilty of committing dacoity. So it is option number D. Believing sugar to be arsenic or poison, A mixes the same into B's food with the intention of causing B's death. B eats the food but does not die. A is guilty of attempt to commit murder. A signs his own name to a bill of exchange, intending that it may be believed that the bill was drawn by another person of the same name. A has committed the offence of cheating, fabricating false evidence, cheating by personation, forgery. He has committed forgery. A finds the key of Z's house, which Z had lost, and commits house trespass by using the key he has found. A is guilty of house trespass, criminal trespass, housebreaking, or lurking house trespass. It is option number C. A is intending to kill B by poisoning, gave to B some sweets to eat which were mixed with poison. B took a portion of it and gave rest to C and D. C and D died while B survived. A is liable for murder. Which one of the following cases does not belong to the same group? P. Rathnam vs. Union of India, Bachchan Singh vs. State of Punjab, Jian Kaur vs. State of Punjab, Aruna Shaunbag vs. Union of India. So, Bachchan Singh. A and B entered a shopping mall on a rainy day. A came out and by mistake took the umbrella of B. On reaching home, he realized that the umbrella is of B, and thinking that B must have taken his umbrella, A kept B's umbrella with him and remained silent. A is guilty of criminal misappropriation. X shakes his fist at Z, knowing it to be likely that by doing so he may cause Z to believe that X is about to strike him. X is guilty of use of criminal force, assault, assault with criminal force, or criminal intimidation. It is assault. X is the paramour of Y's wife, Z. She gives a golden ring to X, which X knows that is of Y, and Z has no authority from Y to give it. X dishonestly takes the ring. X is guilty of mischief, cheating, criminal misappropriation, or theft. A is, for the purpose of including B to desist from prosecuting a civil suit, threatens to burn B's house. A has committed no offense, extortion, assault, or criminal intimidation. It is criminal intimidation. A instigates B to cause grievous hurt to Z. B, in consequence of the instigation, causes grievous hurt to Z. Z dies in consequence. A knew that the grievous hurt abetted was likely to cause the death of Z. A has committed abetment of grievous hurt, abetment of culpable homicide not amounting to murder, abetment of murder, culpable homicide not amounting to murder. It is abetment of murder. In criminal conspiracy, which one of the following is essential? Common motive, common object, common intention, or agreement. It is the agreement. Z, under the influence of madness, attempts to kill A. A has a right of private defense up to the extent of causing death, grievous hurt, assault, death. The case of Bachchan Singh versus State of Punjab is considered to be an important decision in the context of abduction and murder, extortion, death penalty, or rape. C. A person who causes bodily injury to another person who is laboring under a disorder, disease, or bodily infirmity and thereby accelerates the death of that person shall be deemed to have caused death under Section 299, Explanation 1. The right granted under Section 100 of the IPC to the extent of causing death can be exercised against any assailant who may reasonably cause the apprehension that death will otherwise be the consequence of such assault. Above rule has been explained by the Supreme Court, in which case Sunil Batra, Brij Kishore, Deo Narayan, Ramaswamy. Option number C. A hangman who hangs the prisoners pursuant to the order of the court is exempted from criminal liability by virtue of which section of the IPC? It is section number 78. The provision with respect to injuring or defiling a place of worship with intent to insult the religion of any class is enumerated in which of the following sections of the IPC? This is given under section number 295. X induces a 16-year-old daughter to go to a particular office where she will have to face an interview as a formality for a promised job. As planned by X, the minor girl was forced to illicit intercourse by the man whom she was supposed to meet at that place. Offence committed by X will squarely fall within which of the sections of the IPC? 376, 354, 360 or 366A? Option number D. A and B have been accused of an offence where the accused persons had no intention of causing the death of any person and no injury was found on the deceased, which was sufficient to cause the death in the ordinary course of nature. As per medical opinion, injuries were not likely to cause death. It could not be established as to which of the two accused inflicted injuries on the head of the deceased. Accused shall be convicted under which of the sections? He would be convicted under section number 326, read with section 334. Section 34 for voluntarily causing grievous hurt. In Dhananjay Chatterjee versus State of West Bengal, accused raped a young girl and murdered her. Punishment awarded by the Supreme Court of India to the accused was death penalty. Which one of the following is not an essential element for the defense of accident under IPC? Absence of criminal intention and knowledge. Act must be lawful. Means must be lawful. Act must be done with due attention. Act must be done with due attention. Under IPC, nothing is said to be done or believed in good faith which is done or believed without due care and intention. In which one of the following cases Supreme Court declared 309 of IPC is not unconstitutional and does not violate 21 and 14 of the Constitution? P. Rathnam's case, Chenna Jagdishwar's case, Jian Kaur's case, or Sanjay Kumar's case? It is option number C. During inquiry or trial under 309 of the CRPC, a magistrate can remand the accused for a maximum period of not exceeding 15 days at a time. A person accused of an offence before a criminal court or against whom proceedings are instituted under CRPC has a right to be defended by the pleader of his own choice. Of his own choice. An order for custody and disposal of property under 451 of the CRPC is a final order, interlocutory order, directory order, or a temporary order. It is interlocutory order. Which one of the following statements is not correct in relation to medical examination of an arrested person under CRPC? Accused may be asked to undergo medical examination under Section 53. Medical examination of a person accused of rape is conducted under 53A. An arrested person can submit an application to the magistrate for the medical examination under 54. Request of the arrested person for the medical examination cannot be rejected by the magistrate under section number 54. It is option number D. Which one of the following is a fundamental right that has been incorporated under section 300 of the CRPC? It is the principle of autrefois convict and autrefois acquit. Maintenance under section 125 CRPC cannot be claimed by a wife who has obtained divorce from her husband, a wife living separately by mutual consent, a wife refusing to live with her husband owing to his extreme abusive and violent behavior, an illegitimate minor child. The correct answer is option number B, a wife living separately by mutual consent. Which of the following is not correct as per the provisions of CRPC? Summons issued by a court under this code shall be in writing, in duplicate signed by the officer of High Court and shall bear the seal of court. Under section 69, service of summon on a witness may be by a registered post. Bailable warrant of arrest contains a direction that the person named in the warrant need not be arrested if he executes a bond as per the terms of the warrant. Every warrant of arrest shall remain in force until it is cancelled by the court which issued it or until it is executed. The correct answer is option number C. As per the provisions of CRPC, court is empowered to summon any person as a witness only at the stage of inquiry or trial, only at the stage of trial, only at the stage of inquiry or other proceeding, or at any stage of inquiry, trial, or other proceeding. At any stage. All evidence taken in the course of the trial or other proceedings must be taken in the presence of accused, accused and pleader, accused or when his personal attendance is dispensed with in the presence of his pleader. Correct answer is option number C. When an accused person is pardoned under section 306 of the CRPC, he becomes a witness for prosecution, becomes an ordinary witness, should be examined as a witness first in the trial court, becomes a witness for the defense. Option number C. Which one of the following statement is not correct with regard to the provisions of CRPC? If the absconding person against a proclamation who it has been issued and published does not appear in the court within the prescribed period, his property may be attached under section 83. Where property of a proclaimed offender is attached and receiver is appointed thereof, power, duty, liability of the receiver shall be the same as those of a receiver appointed under CPC. If the proclaimed offender does not appear before the court within 2 years from the date of publication of the proclamation, his property shall be confiscated by the state. The correct answer is option number C. A warrant of arrest may be executed at any place in India. At any place in India. A person arrested has a right to be informed of the grounds of his arrest in brief only, English Hindi, detail, in details and in the language understood by the accused. This is option number D. In acquittal, a co-accused can be a witness for prosecution only, defense only, both, or maybe an informal witness. Informal witness. If the accused pleads guilty, the judge has the no discretion to convict him, discretion to convict him, the discretion to convict him after recording his plea, the discretion to convict him depending upon the corroboration of evidence. Correct answer is option number C. A person arrested by police must be produced before the judicial magistrate who has the jurisdiction. If the judicial magistrate is not available, accused can be produced before any executive magistrate who is so empowered. In which one of the following cases Supreme Court recently laid down the registration of FIR in cognizable offences is mandatory? D.K. Basu, Lalita Kumari, Madhubala, Sakiri Vasu, Lalita Kumari. Which one of the following is not correct in respect of confession under 164 of the CRPC? Must be voluntary, must be recorded by the magistrate, must be recorded by the judicial or the metropolitan magistrate, accused must be told of his freedom not to speak against himself. It is option number B. Where two courts subordinate to two different high courts have taken the cognizance of the same offence, a question related to which of the subordinate court can inquire or try the offence shall be directed by parties concerned, session court of the two subordinate court, high court within whose appellate jurisdiction the proceedings were first commenced, and the Supreme Court. So it is a high court. One magistrate got information from a person and referred the same to concerned police station to investigate the matter. The investigation report submitted by the police shall be treated by the magistrate under as a report under 173 of the CRPC, 200 of the CRPC, a complaint, an inquiry by the court, or it depends upon the discretion of the court. It is option number A. X causes the death of Y. After conclusion of investigation, police submitted the report under 173 CRPC. Cognizance can be taken in the case by Court of Session, Court of Magistrate who has jurisdiction, the Court of CJM, or any of the courts of magistrate of second class. It is the Court of Session. Which one of the following is not correct? Court may alter or add any charge any time before the pronouncement of judgment. There shall be a separate charge for distinct offences. Any number of offences of same kind in a year can be charged together. Offences are of same kind when they are punishable with same amount of punishment. Option number C. An accused can be discharged by the magistrate who takes the cognizance, court which has competent to try the case, police, CJM or court of session. It is the magistrate who takes the cognizance. Plea bargaining is permitted where punishment provided is imprisonment for more than 7 years. Offence is committed against a woman or a child under 14 years of age. Offence is related to Cinematograph Act 1952 or offence is under section 153 or 160 of the IPC. The option is D. The compounding of an offence as per section 320 of CRPC shall have effect of discharge, conviction, dropping of charge. It is acquittal. When a witness shall be compelled to answer a question, it is decided by PP, advocate of the accused, court, witness himself. It is C. Hostile witness is a witness, gives evidence in favor of the party that called him, does not speak the truth, gives evidence in favor of the opposite party. Option number C. Oral evidence given in court must be, may be presumptive, must be indirect, may be deductive, must be direct. It must be direct. Which one of the following evidence may not be admissible in a court of law? By a spouse as regards their communication. Court for the purpose of Indian Evidence Act does not include judge, magistrate, arbitrator, person legally authorized to take evidence. So it does not include arbitrator. The case of Sarath Chandra Dev versus Gopala Chandra Saha deals with estoppel. Statement made in police custody by the accused amounts to confession when that party of the statement which leads to the recovery of the object. Statement is made voluntarily. Statement is made in presence of the other party, or the statement is made while undergoing medical treatment. So it is A. Oral admissions as to the contents of electronic records are relevant when the genuineness of the electronic record produced is in question. No judge or magistrate can be compelled to answer any question as to his own conduct in a court, as such judge or magistrate except upon the special order of High Court, Supreme Court, the court to which it is subordinate, or court having administrative control over him. Option number C. Leading questions can be asked in examination in chief even if objected to by the adverse party, re-examination even if objected to by the adverse party, any examination even if not objective, or cross-examination. So this is cross-examination. Under section 113A of the Indian Evidence Act, in which one of the following circumstances the court may not presume abetment of suicide by a married woman by her husband or relative? So, this is when the married woman committed suicide after 10 years of her marriage. Presumption as to electronic record under Indian Evidence Act is drawn by the court where the record is 5 years old, 10, 30 or 13. It is 5 years old. According to the Indian Evidence Act, expert is a person who is especially skilled in foreign law only, science or art only, identity of handwriting or finger impressions only, foreign law, science, art or hand writing or finger impression. Option D. According to the provisions of Evidence Act, a fact is said to be not proved when it is neither proved or disproved. In criminal cases, which one of the following statements are correct? Fact that accused person is of a good character is relevant. Fact that accused person is of a good character is not relevant. Fact that accused person has a bad character is relevant. Fact that accused person is of a dubious character is irrelevant even if the evidence to the contrary has been given. Option number A. Which one of the following statement is not correct? Dying declaration may be oral or in writing. Where there are two or more dying declarations in a case, there must be similarity of contents between them. FIR recorded under 154 CRPC may be admitted as dying declaration. Statements of dying declaration cannot be recorded by a police officer. Option number D. Which one of the following is not mentioned under section 14 of the Indian Evidence Act? Intention, rashness, good faith or conduct. Option number D. Which one of the following statement is not correct in relation to documentary evidence? Where a document is executed in several parts, each part is primary evidence. A counterpart is a primary evidence against a person who has not signed it. Oral contents of the contents of document is a secondary evidence. A document must be proved by its primary evidence except where a party is entitled to give secondary evidence thereof. Option number D. The question of proving a document arises when its execution is denied by the adverse party. In such a case, a public document can be proved by a certified copy under section number 77 of the Indian Evidence Act. Section 101 Evidence Act states, whoever desires the court to give judgment as to any legal right or liability, dependent upon existence of fact which he asserts, must prove the existence of that fact. This means that proving of a fact means proving it beyond doubt. Option number D. The presumption of law under section 111A of the Evidence Act is not applicable where an offence has been committed under Section 121, 121A, 122, 123 of the IPC is committed in a disturbed area and it is shown to the court that the accused was present in the area at that time, is committed against the state by firearms or explosives in a disturbed area and it is shown to the court that the accused was present in that area at that time, or under section number 151, 146 and 153 of the IPC. The correct answer is option number D. The case of Chilkuri Venkateswarlu versus Venkatanarayan deals with estoppel, affairs of state, proof of legitimacy, dying declaration. Option C. Secondary evidence does not mean certified copies, copies made from original by mechanical process, copies made from the original and compared, document itself produced for the inspection of the court. Option number D. Admissions according to the Indian Evidence Act may not be proved as against the person who makes them, can be proved by on behalf of person who makes them, may not be proved as against the person who makes them or his representative in interest, can be proved by or on behalf of the person who makes them or is representative in interest. Option number D. Section 112 of the Indian Evidence Act is based on the principle that law favors legitimacy rather than bastardity of children. It is conclusive presumption and can be rebutted only on the grounds of non-access of parties. Preamble is useful in constitutional interpretation because it uses vague and value-loaded words, contains the real objective and the philosophy of the constitution makers. Option number B. Supreme Court of India does not have an original exclusive jurisdiction regarding a dispute between Government of India and states, the Government of India and one state on one side and one or more states on the other, two states, the Government of India and a foreign embassy located in India. Option number D. The governor of a state has the power to constitute a finance commission to review the financial position of panchayats. Section number 99. Question number 99. The seat of member of parliament may not become vacant if he or she absence from the meeting of the house for 8 weeks, holds a membership of both houses of parliament, holds the membership of one house of parliament and also that of a state legislature, is under any acknowledgement of allegiance to a foreign state. Correct answer is option number A. Under which law it is prescribed that all proceedings in the Supreme Court shall be in English language. It is given under 348 of the Indian Constitution. It has been held by the Supreme Court in several cases including Maneka Gandhi case that pre-decisional hearing in all cases is not mandatory. Even the post-decisional hearing in some cases is a good substitute. Which one of the following correctly states that the law relating to post-decisional hearing? The pre-decisional hearing may frustrate the very purpose of taking action and thus pre-decisional hearing is not required. Post-decisional hearing serves no useful purpose. Post-decisional hearing may be useful in some cases depending upon the facts and circumstances of a case. Post-decisional hearing can be a substitute for pre-decisional hearing in all cases. Correct answer is option number A. Which one of the following statement is correct? A mentally retarded woman who has a fundamental right to bear a child. A visually retarded woman who has no fundamental right to bear a child. A person with physical disabilities cannot contest elections. A physically disabled person cannot seek admission in an educational institution except against seat reserved for them. Option number A. Option number A. Which one of the following is not come under the expression state as defined under Article 12 of the Constitution of India? Government of India, Municipal Corporation, State Bank of India, all private universities established by the Acts of State Legislature. It is option number D. In which one of the following cases it was held for the first time by the Supreme Court of India that judicial review is a basic feature of the Constitution? A.K. Gopalan, L. Chandra Kumar, Keshav Nanda Bharti vs. State of Kerala, Maneka Gandhi. It is L. Chandra Kumar. Which of the following statement is not correct? No person has a fundamental right to refuse to give blood for DNA test to decide paternity of a child. No person has a fundamental right to refuse fingerprint for use as evidence. Every person has a fundamental right to refuse payment of tax on ground that government is using various taxes by providing subsidy for pilgrimage for a particular religion. Option number C. Which of the following statement is not correct? Newspapers can publish parliamentary proceeding. Newspapers can publish any part of the parliamentary proceeding with the permission of the speaker. Newspapers have the freedom to publish expunct portions of the speech of a member of parliament. Parliament has a freedom to publish its proceeding. Option number C. Which of the following cases is a leading case on the issue of transfer of judges? This is S.P. Gupta versus Union of India. The case of I.R. Kohlu is related to fundamental right, DPSP, Article 31C of the Constitution or the 9th Schedule and 31B of the Constitution of India. Option number D. Principle of evolving a UCC is stated in Article 44 of the Indian Constitution. Which of the following tribunals commission has been set up in accordance with the provision of Article 323A of the Constitution? This is administrative tribunals. Constitution of India in Part 21 does not contain special provision with regard to which one of the following state? Maharashtra, Andhra Pradesh, Assam, Himachal. So this is D. Which of the following statement is not correct? Article 370 is a temporary provision. Article 370 may cease to be operative if the President so declares by a public notification according to prescribed procedure. Any dispute arising out of the instrument of accession entered into by the former Maharaja of J&K can be adjudicated only by the Supreme Court. Article 1 is applicable to the state of J&K. Option number C. Which of the following is not essential for creation of a new state? The consent of state from which territory is to be taken out is mandatory. The Parliament can create a new state simply by enacting a legislation. The fifth schedule to the Constitution. The fifth schedule to the Constitution of India has to be amended for creating a new state. There is no requirement of seeking union territory, the opinion of the union territory which is converted into a state. So option number A. Suppose the central government decides issue licenses to private parties. Which of the following would be a valid procedure to do so? It would be by inviting sealed tenders and open public auction as the government considers best in the public interest. In India, union government cannot issue directions to the states in which one of the following cases? Protection of railways falling within the state, to ensure compliance with laws made by Parliament, to ensure the exercise of executive power of the union is not impeded, to ensure that water of interstate rivers is not unduly exploited. Option number C. Which of the following statements is not correct? No person can be prosecuted and punished for the same offence more than once. No person can be convicted of any offence except for violation of a law in force at the time of commission of the act charged as an offence. No person accused of an offence can be compelled to give specimen of his signature or thumb impression. No person can be subjected to a penalty greater than that which might have been inflicted under the law in force at the time of the commission of offence. Option number C. Which of the following statement is not correct? The Constitution of India contains provision regarding the administration of scheduled areas and scheduled tribes in any state. The Constitution of India contains provision regarding the administration of tribal areas and scheduled tribes in the state of Assam, Meghalaya, Tripura and Mizoram. Parliament may by law form within the state of Assam an autonomous state comprising of tribal area, a law defining the matters with respect to which the executive power of autonomous state shall extend can be amended by Parliament by simple majority. Option number A. PIL is maintainable in respect of which one of the following matters? Service matters, policy matters, parliamentary proceedings, black money deposited in banks outside India. Option number A. Which one of the following articles of the Constitution of India permits states to make special provision for children? Article number 15, clause 3. Bijoy Emmanuel versus State of Kerala is a case related to protection of religious belief, fundamental duties under Article 51 AE of the Constitution, performing Tandav dance, observing religious practice at any location. It is option number A. And with this, we are over with the previous year paper of 2015 of the CBI. I hope this helps you to practice for your upcoming exam. Thank you.